seated.
Good morning, everyone.
Please.
Good morning, everyone. Today is Tuesday, July 14th, 2026. This is the criminal court session at Plymouth Superior Court before the Honorable Justice Mark Gildea. Your Honor, the matter before the court is civil action 2683 CB 00541. Jennifer McCabe et al. Versus Karen Reed et al. Counsel, if you could please state your name for the record, we start with the plaintiffs.
Good morning, Your Honor. Chris Maddy on behalf of the plaintiffs.
Good morning, Your Honor. Kieran Murphy on behalf of the plaintiffs.
And good morning, Your Honor. Jim Tuxbury, also on behalf of the plaintiffs.
Morning.
Good morning, Your Honor. Jeffrey Pyle on behalf of defendant Aidan Kearney.
Good morning, Your Honor. Adam Doherty, also from Mr. Kearney.
Good morning.
Good morning, Your Honor. Damon Seligson for defendant Karen Reed.
Morning. So we're here on motions to dismiss and pursuant to paragraph 8 of the Superior Court Standing Order 196 for in-person hearings where no person appears remotely, members of the public shall attend in person. Courtrooms open to the public. So the parties have all submitted extensive memos on the issues raised by these motions. I can't say at this point that I read every single transcript that was included in Attorney Sellerson's submission, but I have read and reviewed those that I believe to be necessary. And I have read all of the extensive briefing on the issues in multiple affidavits, so please keep that in mind. I don't need a lot of background here. We all know the Duracraft framework to which the SJC has returned. There's two steps. First, have the respective defendants shown that the claims against them are based solely on protected petitioning activities. To survive this first stage, the defendants each must show that the challenge count has no substantial basis in conduct other than or in addition to their alleged petitioning activity. If a defendant cannot make such requisite showing, their special motion to dismiss is denied. If a threshold showing is made, we go on to step 2, which is have the plaintiff shown that a defendant's exercise of the right to petition lacked any factual support or basis in law. It has caused the plaintiff's injuries. Now, on the first step, I only need to conduct a facial review of the amended complaint to identify which factual allegations serve as a basis for a particular claim. I may need to look at other documents in the anti-SLAPP record to determine whether these allegations fall within the statutory definition of petitioning activity. That's an objective assessment to be made based upon the documents before me without resort to judicial fact-finding. I say the standard simply so the rest of you don't have to repeat it. We all know it, we don't have to repeat it. So let me start off with a few questions. Let me start with Mr. Kearney's attorneys. Let me start with the plaintiffs. Who's going to argue on behalf?
I am here.
Okay, tell me this. Do the plaintiffs concede that Mr. Kearney's actions were reasonably likely to enlist public participation?
No, we do not.
Okay, so does everyone have their copy of the amended complaint?
Yes, Your Honor.
Anyone not have it? So let's look at paragraph 106. If anyone doesn't have it, the clerk has his copies.
See paragraph 106, Your Honor.
106, yeah. It appears, if you look at paragraph 106 and paragraph 126, in each of the allegations for plaintiffs, it does appear you're conceding that his actions were likely to enlist public participation. So tell me how I'm misreading those paragraphs.
Your Honor, there are some defamatory statements and some conduct that he engaged in that we agree did enlist public participation in what we claim was a harassment campaign towards the plaintiffs, not participation in any matter or issue that was under review by a judicial body. But there was other conduct and other defamatory statements he made that we do not believe was likely to enlist public participation. And I can give you some examples of those. So for example, when Mr. Kearney confronted Ms. McCabe and her family at a youth lacrosse game, he did that on his own in the setting confined by a lacrosse game and shouted "cop killer" at her and in the vicinity. There was nothing about that conduct that was likely to enlist public participation in any legitimate petitioning activity. To the contrary, it was a verbal and physical confrontation at a lacrosse game directed towards Ms. McCabe. Voicemails that he left for Brian Allen and the McCabe family, which was essentially direct communication with them in which he defamed them directly. That type of conduct, although he later published it to an audience, that type of conduct is actionable on its own and not likely to enlist public participation. And so these are examples I give you, Judge, as to show that there is some conduct that Mr. Kearney engaged in that was not for a viewing audience, let's say, although he may have later published it to a viewing audience. And then some conduct that is actionable that was not likely to enlist public participation. I also want to just draw a distinction, Judge, if I may, between certain actions described by Mr. Kearney in his memorandum, which are not an issue in this case. So, for example, and I don't want to get too far afield from your question or get into general argument, but the idea that Mr. Kearney may have at times been involved in activities that were critical of the DA's office or critical of the state police, the Canton Police Department, that is separate conduct and not alleged by us to be actionable than the conduct that we claim was illegal, which was a prolonged, persistent defamation and harassment campaign directed at the plaintiffs. And there's no question that he sought to enlist his audience in that same illegal conduct. But that's only step one of the analysis. That is whether somebody summons a mob or attempts to enlist them in some sort of participatory activity. That enlistment of public participation needs to be in furtherance of some petitioning activity. And that's where, we would argue nothing he was doing was petitioning. It's not enough to say, oh, I can make false accusations against private citizens and provoke others to outrage. Yes, he did do that. But that's not what the petitioning test is. The petitioning test is whether that was done in service of any legitimate petitioning activity, which, as we say extensively and as I'll argue later today, was not what he was doing.
Let me ask a different question. Your opposition talks about Mr. Kearney acting on Ms. Reed's behalf rather than his own. And one possible reading of Cardinal, which everyone seems to cite here, could be that the anti-SLAPP statute protects those looking to advance causes in which they believe, and that the publication may be protected even if they're not intended to protect the writer's own rights. So if Cardinal does stand for that broad proposition, what do you say to Mr. Kearney's affidavit that essentially says he was advocating for cause he believed?
So a couple of things in response. And I'll address the Cardinal case more substantively later. It is clear that what Cardinal stands for is what I think is a fairly unremarkable proposition, that a citizen who has an independent interest in a cause can engage in petitioning activity in support of that cause and invoke anti-SLAPP protections. That, I think, is true. What we allege, and what Mr. Kearney seems to admit, is that this wasn't something he was doing independently on his own, that he wasn't seeking to engage in petitioning activity of his own, but in league with Ms. Reed and in part for a financial motive. And so the reason that we think Cardinal is important, in addition to the fact that Cardinal involved direct petitioning activity to governmental agencies, which we don't have here, is because it suggests that part of the analysis is if somebody is petitioning for a cause, whether they have an independent interest in promoting that cause versus whether what they are in fact trying to do is act in service of another's interests, which is what we believe he was doing. Obviously, he was self-interested from our perspective in gaining notoriety, celebrity, and profit. And so that's why we think Cardinal's observation that the petitioners there had independent, long-standing interest in this issue of the environmental consequences of the BP oil spill is different than what we have here.
So who's speaking on behalf of Mr. Kearney?
I am, Your Honor.
So if you believe that Cardinal stands for that broad proposition, I mean, the plaintiffs point to Cobra and Facillo, I think is another case they talk about. In the statutory language of 59H that restricts coverage to defendants who petition the government on their own behalf.
Yes.
And they suggest that your reliance on Cardinal is misplaced. So tell me, how are Mr. Kearney's actions similar to the Cardinal activists?
From the very beginning of his blog posts, long before the Karen Reed case of killing John O'Keefe, Aidan Kearney exposed police corruption. He wrote stories about police who had basically miswritten police reports in order to protect the daughter of a judge, resulting in a major ethics investigation. He wrote articles about a state police officer who had misrepresented on her application that she had been following the laws, and in fact she had run a marijuana operation. His whole message and his whole sort of body of work has been to call out police corruption and misuse of state power. This was part of that. From the very beginning, he alleged that Trooper Proctor's investigation of this case was corrupt.
Well, let's go back to Cardinal.
Sure.
Cardinal lists activists at a personal stake, right?
No, the activist, only one of the activists even lived in Louisiana. The other did not. They did not have a personal stake in the outcome, and the SJC's decision did not turn on whether they had a personal stake in the outcome. The SJC's decision broadly says and clarifies Facillo in case of anybody trying to overread it, that people who petition on their own as citizens about issues that they care about are protected by the anti-SLAPP statute. That is what the petitioners in Cardinal did. They wrote an article about the Deepwater Horizon pollution scandal in the context of a pending judicial case in order to, and this is the SJC's words, increase the amount and tenor of coverage about that issue in the public sphere. That is what Aidan Kearney did here. He is fully protected by the Cardinal case. Facillo and Coburn have to do with people who are under contractual obligations that made it such that they couldn't be deemed to be petitioning on their own behalf. Coburn involved a person who was retained as an expert for the government. And Coburn turns on the fact that you can't be petitioning on your own behalf if you're working for the government and you're sued for your work on behalf of the government. The Facillo case involves a reporter who was contractually obligated with her employer to write objective news articles about public hearings in the North End and was not putting forth her own opinion or speaking out on her own as a citizen about the issues in the North End. It was not for the issues that she was sued about. Aidan Kearney has clearly been speaking out on his own about corruption for a long time, and this was part of that body of work. He is clearly protected by the Cardinal case.
And do you want to briefly respond?
Yes, I would, Your Honor. Two things. First, we allege that Mr. Kearney was essentially in a business relationship with Ms. Reed in that she was providing him, directly providing him, material that he was then using to defame the plaintiffs. That's number one. So they were working directly together. This was not Mr. Kearney acting on his own on an independent mission. This was Mr. Kearney and Ms. Reed, as we've alleged, in a conspiracy to defame the plaintiffs. Number two, what we think is crucial about Cardinal's finding is that the court commented that the petitioners in that case were involved in an effort to directly petition the government. Yes, the conduct at issue involved 4 paragraphs in a magazine article, but they had previously directly engaged with federal agencies responsible for environmental protection and the like. What Mr. is now trying to do is convert whatever history he may have had in his word of exposing corruption or going after the police and making that what he was doing here, when what he is alleged to have done here is not criticize the DA's office, criticize the police department, but very directly accuse private citizens of murder. So that is, I think, never having petitioned the government directly as the activists did in Cardno. So we see Cardno as standing for the important proposition here that anti-SLAPP protected activity has to be tethered in some way to an effort to directly seek redress from the government or indirectly seek redress from the government. Here, Mr. Kearney has not argued in any way that his false accusations against our clients that they had committed murder was a message that he conveyed to the government, that he intended to be conveyed to the government, that he had any mechanism for reporting to the government. And on the one occasion where he actually was given an opportunity to directly petition the government on the issues, he declined by invoking his rights under the Fifth Amendment because he believed, rightly so, that responding to inquiries in connection with any sort of petition would expose himself to criminal culpability. So that's why we think Cardno is important here.
So it's the relevance of his invocation of the Fifth that he did not avail himself of the opportunity.
Correct. I think one of the things that the court is going to be asked to consider is whether there are objective indicia. This is from Blakesley. Objective indicia of the plaintiff's intent to reach a governmental body in his petitioning activity. And one fact that I think is important here is that of all the activity he engaged in, all of which was, in our view, non-petitioning and not intended to reach the government or designed to reach the government, when he had an opportunity to petition the government, he declined to do so. And we think that's an important objective indication that his intent was not to reach the government. In fact, his intent was to attack and defame private citizens.
So, what do you say to the relevance of the Fifth Amendment?
There is no relevance to the invocation of the Fifth Amendment because he's being sued for his statements that he made well outside of the courtroom. Those statements were petitioning. The suggestion that Mr. Kearney did not intend for his message about Karen Read's innocence and the plaintiff's guilt to reach the government is belied once again by the allegations of the amended complaint. They admit that Mr. Kearney was responsible for the hundreds of people who showed up at the Dedham courthouse every day during that trial to protest. Who were they protesting? They were protesting the prosecution of Karen Read. Who was prosecuting Karen Read? The government. Mr. Kearney is clearly the leader of the national Free Karen Read movement. And what do the words Free Karen Read mean? What do they signify other than a demand, a petition that the government do something or stop doing something? That's what he did. Obviously, his words we reached the government. You have in the record early on some of his Canton cover-up stories, a directive to his readers. Email Michael Morrissey at mmorrissey@state.ma.us. That's in one of the very first Canton cover-up articles. He says repeatedly that our presence protesting and doing standouts is intended to let the government know that we are watching and that we will not let an innocent person be railroaded. The anti-SLAPP statute doesn't extend just to speaking in court or petitioning the government directly as in filing a police report. It extends, and I know Your Honor knows this, to statements that are reasonably likely to enlist public participation in an ongoing judicial case. I would submit that Aidan Kearney successfully enlisted the greatest degree of public participation in a judicial proceeding in the history of this Commonwealth.
So let's talk about whether Mr. Kearney was doing it on his own behalf or his read.
Yeah.
There's just claims against him. Can't show the claims against based solely on petitioning. They point to the Judge cross-line of an intent to influence and pressure witnesses, as well as to Judge Julian's finding that Mr. Kearney's purpose was to interfere, obstruct, so please.
Those rulings are not helpful on this motion in the court's past because they turn, as you just mentioned, on the question of intent. And the anti-SLAPP law provides that the motive behind protected petitioning activity is not to be considered at the first stage of the analysis, which is where we are. That's been the law ever since the Office 1 versus Lopez case, if not before, back in 2001. And the witness intimidation charges relate to conduct that is only partly part of this case. The witness intimidation rulings by those two judges do not analyze whether Aidan Kearney's statements meet the statutory definition of petitioning under the anti-SLAPP statute. Instead, all those decisions say is that there's probable cause to believe that he may have, on the right proof, committed certain crimes that turn on subjective intent. And that is not helpful in the current motion. The current motion looks at statements. The question is whether the statements for which he has been sued meet the statutory definition of petitioning under the anti-SLAPP statute. And the question of motive is not to be considered. And that, not to get off the topic of your Honor's question, but the commercial motive that, okay.
So turn that by Judge Julian and Judge Cross. Statements are relevant.
So, Your Honor, Judge Doolin and Judge Krupp's findings that Mr. Kearney's activity was outside the protection of the First Amendment because it was activity that was intended to intimidate witnesses and harass witnesses is important because it provides you with some insight as to how other judicial officers considered whether or not that type of conduct was constitutionally protected and therefore likely to be petitioned. In fact, what Mr. Kearney has done and what Ms. Reed has done by conspiring with him is pursued an unlawful campaign of harassment and intimidation, and a tool that they used in connection with that campaign was defamation. And so this, I think, the findings of Judge Krupp and Judge Doolin really just point to a truism. And that truism is, in the history of the United States, there has never been a case that we can find in which the court ruled that one citizen may publicly accuse another of murder outside of any reporting to government and be immune from civil liability for it. There's no case. Mr. Pyle has not cited any case. It would be a radical expansion of anti-SLAPP protections for this court to find that. And that is highlighted by Judge Doolin's and Judge Krupp's conclusions that what Mr. Kearney was doing with respect to these witnesses, and again, I think it's important to separate what we've alleged in the complaint, which has to do with conduct directed towards these witnesses, versus other conduct he may have been involved in, relating to the DA or the investigation or whatever it may have been. What we've alleged is a course of conduct directed at these witnesses. What Judge Krupp and Judge Doolin analyzed was the conduct he directed at these witnesses, and they found that there was no constitutional protection for it, which is exactly what we are saying in this case, that there was no constitutional protection for his defamatory and harassing conduct. The defamation here being in service of an effort not to petition the government, but an effort to intimidate and browbeat these witnesses into changing their testimony. And we make a specific allegation in the complaint in that regard, where Mr. Kearney says, this will all stop if you flip. He's not petitioning the government to get these witnesses to flip. He's petitioning the witnesses themselves, and he's encouraging others to intimidate them in order to create that outcome for Ms. Reed.
So, Attorney Pyle, along that issue, it would appear that your position is that the anti-SLAPP statute and the cases interpreting it preclude someone who has been publicly accused of murder by Mr. Kearney from prosecuting an action such as this.
I'm sorry, Your Honor, I don't understand the question. Preclude,
Well, put another way, how can publicly accusing someone of murder be petitioning activity?
oh, easily. It depends on the context in which the statement is made. And I will have to say regretfully that the plaintiffs have broadly overstated the law about this. They say on page 20 of their brief that the law is clear that accusation of criminal conduct is only petitioning if made to the police or other law enforcement agency. That's on page 20 of their brief. There has literally never been a Massachusetts case that has said that. They cite 4 cases in support of that assertion, but none of them say that. And, of course, reports to the police are petitioning, but that doesn't mean that reports that, a statement that the police are investigating the wrong person, who the police should be investigating, are these plaintiffs, Brian Albert, Brian Higgins, Jennifer McCabe, Colin Albert. They should be investigating them. And the fact that they didn't even consider investigating them shows that this police department is corrupt. That's been Aidan Kearney's thesis throughout this entire time. In a footnote in their brief, I note that the plaintiffs can see that generally raising awareness about police corruption is and can be protected petitioning activity, they say, but they draw this distinction. Accusing people of murder can't be petitioning. In this case, they are all part of the same ball of wax, because the reason that Aidan Kearney believed that Trooper Proctor and the other investigators were corrupt was because they didn't even consider investigating the people at 34th Fairview on that night in question. Instead, they decided to protect, he said, a Boston police officer and other powerful people in Canada. The corruption is bound up inextricably with the allegation that plaintiffs were responsible for this murder and not Karen Reed. The North American Exposition Company case says that in deciding whether statements are petitioning, you must look at them in the context in which they were made. The context is extremely important. And to say in the abstract that it can never be petitioning to accuse somebody of murder ignores that line of cases. You must look at the context in which this all occurred. The pending judicial proceeding against Karen Reed, Mr. Kearney's campaign to try to ensure that those charges would be dropped and the plaintiffs would be charged instead. That is the context in which these statements were made. That is a context that contributes substantially to the finding that this was all petitioning.
Well, let's talk about context for a second, because many of Mr. Kearney's actions could be interpreted as seeking to make the plaintiff's lives miserable. In fact, he says something where he said somewhere, I forget where I read it, that they'll never live a normal life. The plaintiff cited to Judge Salinger's decision in Clay Court versus Fulton for the proposition that hiring private plaintiffs for punishment is not petitioning activity. What's your response to that?
The motive behind petitioning activity, once you establish that it constitutes petitioning activity, is irrelevant. And I would suggest, Your Honor, that it's helpful to look at these allegations on a count-by-count basis. That is what Bristol Asphalt instructs must be done. The defamation count.
You all did that in your submissions.
Well, I would respectfully say we did it better than they did. But on the defamation count, Your Honor mentioned earlier that reviewing the complaint is the first step in deciding what a claim is based on. That entire claim is set up at paragraph 156 in repeatedly publishing false statements asserting or reasonably understood to be asserting that the plaintiffs were responsible for the murder of O'Keefe and a cover-up of their purported role in the murder. Kearney published numerous defamatory statements. That is and then they list the harm and the fault and all sorts of other things that they say provide the foundation of the defamation claim. Absent from that is any allegation that he set out to make their lives miserable. Absent from that is any motive allegation, which isn't relevant in the anti-SLAPP context anyway. The statements that plaintiffs were responsible for the murder were part and parcel of his petitioning about the corruption of the case and everything else. That is what the defamation count is based on. And clear, we say all the counts are based solely on petitioning. But plainly, we say right there paragraph 156, that that's the foundation of the defamation complaint. So anything else about notions of motives to make their lives miserable or that kind of conduct isn't relevant to that defamation, which is the central count in this case.
One response.
I do. I have several responses, if that's all right, Your Honor, in response to what Attorney Pyle was saying earlier. You asked him earlier, why would accusing a private citizen of murder be petitioning activity? And he said, oh, easily. And then he didn't cite a single case in which that has ever been found. That accusations against another citizen, not funneled to the government, not a police report, not a tip to the FBI, not using an intermediary to inform law enforcement that somebody has committed a crime, just speaking it, that another citizen has committed murder falsely, as you have to presume in construing our complaint. He says easily that's petitioning activity, and yet nowhere in the history of the Republic, as far as we can tell, has any court ever concluded that. In fact, to the contrary, we cite cases where, as Attorney Pyle says, petitioning activity is found where citizens report criminal conduct to law enforcement. But in those same cases, and I would urge you to consider Bowman, which is a First Circuit Court of Appeals case, those same cases acknowledge that the reporting of criminal activity to law enforcement is petitioning activity, but then reporting of it to third parties is not. And in that case, the plaintiff was somebody who had been accused of sexual assault. The accuser had previously made a complaint to the FBI and another governmental agency. Subsequently, she informed people with whom that individual was doing business of the same complaints. And the First Circuit concluded that while the earlier reports to law enforcement may have been petitioning activity, the reports to third parties were not. And here's the kicker. The reports to the third parties were to staff of congressmen. And even there, the First Circuit held that that was not petitioning. And there are other cases that we cite in which wrongdoing is reported outside of governmental channels and not given petitioning protection. I want to talk about Attorney Pyle's comment about context, that it's important to consider context. They cite North American expositions for that principle. We cite it as well. The context that the court was considering in North American expositions wasn't the political climate. It wasn't the overall course of conduct. It wasn't, some atmospheric assessment of what was going on in the world. It was the context of the forum in which the statement was made. And there, the forum in which the statement was made was to the South Boston Community Foundation, which was created by the legislature, placed in the executive branch, and responsible for distributing public funds. And that was the context that North American expositions, which they cite, concluded was an appropriate forum in which petitioning activity occurs. Here, what they are encouraging you to do is say, Judge, consider the gestalt of what Mr. Kearney was involved in. Consider that he was in, as a general matter, using his YouTube page and his for-profit entity to talk about issues. That's the context in which you should find that his accusations against private citizens of murder were petitioned. No, that's not what the cases say. The cases say, the North American expositions in particular says, that when considering context, it is the forum in which the statements are being made. And I think that that's a crucial distinction. I do want to say one other thing in response to Attorney Pyle.
Just one.
I can wait as well, because I know you came out asking questions, and I don't know whether, Judge, at some point you want to, whether we should make more expansive remarks, but I'm happy also if you have something that you'd like to key in on to hold up. I wasn't quite, now I lost my train of thought. Oh, I think it had to do with intent and motive. It is absolutely true that the court should not consider Mr. Kearney's motive at this point. And yet, Mr. Kearney in his memorandum spends pages and pages and pages telling you that he was motivated by a sense of justice, that he was motivated to shed a spotlight on this criminal justice proceeding, that his motive was to spur others to action. None of that matters. Even if true, it doesn't matter. What matters is what he did and whether there is objective indicia of his intent. So his self-professed motives here, and the same with Mrs. Reed, don't matter. What matters is whether the record, with respect to the statements he made to our clients, presents objective indicia as to whether what he was doing was intended to reach the government. And here, what we say is that the objective indicia, the fact that he never actually reached out to the government, the fact that he declined an opportunity to do so, the fact that he encouraged his audience to use coded language to defame the plaintiffs. Coded language, meaning language that by its very nature would obscure the government from knowing what he was doing. The fact that he engaged in private confrontations suggests that there is an objective indicia that he was not looking to reach the government. That's what matters, not his after the fact self-comparison to Oliver Wendell Holmes. What matters is the objective indicia in the record as to what he did.
So no more, we'll get into it sometime. So, Attorney Barlow, let's talk a moment about public participation. When I read your findings, I just get the sense that there's a little bit of overreach. And it's supposed to go to any statement reasonably likely to encourage consideration or review of the issue. The language goes on. But how does posting to social media or encouraging people to participate in a rolling rally at plaintiffs' homes, the type of public participation contemplated by the statute?
There have been a number of anti-SLAPP cases that have turned on use of social media to inform and mobilize other people. I had the very first one that involved the plan to build a racetrack in the Plain Ridge Casino. And the Superior Court there held for the first time that posting on Facebook is protected by the anti-SLAPP statute. Posting on social media is the way today in which people connect with each other. Aidan Kearney has done that to great success in getting people involved in these issues. Indeed, posting on social media and posting on the internet generally, I would point out, is what led your affiants Rita Lombardi and Paul Cristofaro to do things that are clearly a public petition. Going to Canton Town Meeting, going to the State House. Mr. Kearney, by the way, this suggestion has been made, Mr. Kearney never petitioned the government on his own, but they allege in their amended complaint he was there protesting at the Denton Courthouse. He was also up at the State House protesting to get the Attorney General involved in all of this. He decided that his words, his direct police report from Aidan Kearney to the Canton police wouldn't have done anything. He wasn't a witness to this murder. He reasonably determined that the facts would show that mobilizing thousands of people to protest against this unjust prosecution would be a way, potentially, to get the charges dismissed as he believed they should have been, by putting pressure on elected officials to do so. That is core protection.
Encouraging people to participate in a rolling rally.
The rolling rally, Your Honor, is very much participation and likely to lead to further public participation. That was a caravan of cars that started in a supermarket parking lot, went to various people's houses, didn't stay for too long, ended up with a protest in front of the Canton Police Department. That is I recognize that he's been indicted for that conduct, but nobody was. It was a peaceful protest in cars, and Mr. Kearney is vigorously fighting, of course, the criminal prosecution for witness intimidation that arises out of that rolling rally. It was also heavily promoted online, such that people who weren't there could see, look, there's lots of other people who believe so strongly in this cause. They're going to go out on a sunny day and participate in a public event. That is also reasonably likely to enlist further public participation by others in this cause. So it is part and parcel of the petitioning activity in the case, and it meets the statutory definitions. Also, he's been sued, once again, for statements accusing plaintiffs of murder, statements that were made in connection with the ongoing criminal case. There's not just one element of the anti-SLAPP definition we're relying on. We're also relying on the statements that, at least during the entire time of the Karen Reed prosecution, his statements were made in connection with a pending judicial proceeding and were intended to reach the government directly or indirectly.
Let me turn to a few questions relative to the Reed motions. First of all, whenever you start arguing, I don't need to have the party spend the time of 12:06 hard. I can review the four corners of the complaint or the other complaints, whatever complaint I determine is the offer of the complaint. And I'll consider your written submissions. But let me start with the plaintiffs. Why would you not get responded to the issue raised in the June 23rd amended motion to dismiss, or request from the court more time to do so?
Your Honor, we do respond to the June 23rd motion to dismiss. It's our position that the opposition that we filed following service of both the June 18th and the June 23rd motions to dismiss address both of them, all of the issues raised in both of them. We didn't feel that we needed more time to respond. In fact, we thought that the appropriate course.
But you take the position that I shouldn't consider the amended motion, the second motion.
Well, we do. I mean, we think it was a violation of the rules for them to serve it out of time without permission from the court. We think that it didn't comply with 9C. We think there are a whole host of reasons why the court shouldn't consider it. But if the court were to consider it, our opposition, which was served after we received service of both that and the June 18th motion, apply to both.
You took the time to have an affidavit submitted, which included a copy of the June 18th motion to dismiss.
Yes, we did do that. I mean, I'm not sure I understand
Well, then
the suggestion.
why did you do that? You responded to the June 23rd.
Well, Your Honor, we thought it was important to bring to the court's attention what we consider to be Ms. Reed's gamesmanship with the rules of procedure. So she serves on us a motive.
That's why you did it. All right.
Yeah, that's why we did it.
So, Attorney Sullivan, apparently the original motion to dismiss that was served addressed the plaintiff's original complaint, not the first amended complaint. Is that correct?
The original motion addresses the complaint, which is extended
No.
by an amendment.
Hang on. It would appear, from what I saw, that, and I'm happy to give you, because I did compare and contrast the original motion
Yes, Your Honor.
and the second one, but what it appeared is that maybe someone responded to the wrong complaint. I don't know. But after the issue was brought to the attention, your attention, or whoever in your office, you unilaterally filed an amended motion on June 23rd. And Attorney Martin references 9A. I might have missed it in the 9A, but I don't quite see how you get to do that.
Well, Your Honor, the June 23rd motion to dismiss simply corrects the caption. But Your Honor, if I may answer the question.
Who doesn't allow it, does it? Does Rule 9A allow me to send a motion and then a few days later say, I changed my mind, here's another one?
Nothing was changed. We didn't change. No one changed their mind, Judge. What happened was there was an amended complaint which simply adds additional factual allegations. There's no new.
Well, why wouldn't you ask for permission? Why didn't you just do it?
Because we thought we could reasonably deal with counsel. That's why, Judge.
Yeah, but
And I don't think there's any prejudice to them by getting a complaint.
There's prejudice to the process, and I just don't know. It just seems to me this decision such as that just, I don't know whether it's a showing of entitlement or arrogance. I don't know what you.
It's neither, Judge. It's simply correcting a motion to dismiss a complaint that was subsequently amended that has absolutely no change substantively, no change in parties, counts, theories, or anything other than additional facts, which we address in a reply. So it's a correction of the original motion. We reached out to counsel after they pointed it out to us. Asked them
They
if,
told you they weren't going to accept it.
well,
So you decided, okay, I don't care what they say, we're just going to do it.
how are they prejudiced? We even offered them more time to respond. It's form over substance, Judge, with all due respect. The arguments are still presented. The theory that they're advancing is still addressed. There's no prejudice. There's no change except some number paragraphs. And where it said Plymouth, it had said Barnstable because this is where the case originally originated. So while I understand the mechanics of the process under 9A, really haven't violated anything. We've responded to the amended complaint, which is purely an extension of the original complaint. There's cases that hold for that position. It's not an inoperative, superseded complaint. It's an extension of what was initially filed. And we've addressed the arguments.
It was filed as of right. So that's the operative complaint. The amended complaint was filed as of right.
But it still extends what was initially pled at the initiation of this lawsuit, which is a theory that has not changed by virtue of an amendment. What happens in the amendment is some additional factual allegations are included.
So why didn't you respond? Why didn't you address those in your June 23rd? For example,
We addressed them in the reply, Your Honor.
right, but you could have done it. You could have done it in amended motion, couldn't you? Because the reply is not to argue stuff you might have missed. The reply is to talk about new stuff.
But we are under no obligation to address every single factual allegation.
But you're also under, you don't have the ability just to throw in a reply because you want to put in something you might have forgot to address.
The purpose of a reply is to reply to the arguments that are in the opposition to the motion to dismiss, which is what we've done. And I'm here to argue it verbally as well.
Let's talk then for a moment about the reference to the statements that Ms. Reed made in 2024 to Mr. Muir.
Yes, sir.
And you addressed that in a reply. First of all, your reply uses the word allegedly in describing Ms. Reed's words. Do you not concede that she said those things?
Well, the alleged is behind what the purpose.
It says her alleged words. That's what your reply said.
Your Honor, I haven't seen the documentary, so I am responding and advocating for my client's argument. So I'm not going to admit that that's what she said until I've seen it. So for the purposes of argument, I must have used the word allegedly. But the arguments are that is petitioning activity.
Let's take a look at paragraph 33 of the complaint. Yeah. Yeah.
Paragraph 33 of the amended complaint, Your Honor.
Yes. And that's where plaintiffs allege Ms. Reed was the source of a blog post. And which she said Jen McCabe was the mastermind of the cover, calling her head only to kill Mr. O'Keefe. And I use that particular paragraph just as it's in. My broad question is, how are Ms. Reed's statements to Mr. Kearney, not things in court filings, but her statements accusing the plaintiffs of murder? We'll put another way. Let's start with what category of the anti-SLAPP statute do you put such statements on?
So the anti-SLAPP statute provides at least 5 types of statements that are protected as petition. One is any statement
I know what the 5 are. Just tell them which one.
in connection with a judicial proceeding. This is a statement in connection with a judicial proceeding. From day one, my client has taken the position that she was not responsible for the death of John McCabe, and that somebody else or others were. That's in connection with that judicial proceeding, that protected petitioning activity. The complaint rests solely on that type of language. It's also knowing that Mr. Kearney obviously has a wider audience, he's arguably to enlist participation. So at least 2 statements of the anti-SLAPP statute would cover those statements. From day one, she's taken a position it wasn't her. She was prosecuted twice and acquitted.
Let's go back to the moment to just read statements to Mr. Beer.
Yes, sir.
She suggests in reply the scope of the anti-SLAPP statute. One of the categories being encouraging consideration and review, reasonably likely to enlist participation. So, in the critical trial, the case went to the jury on June 25th, 2020. Correct.
Yes.
Okay. 3 days before, on June 22nd, 2024, Ms. Reed gave an interview to Mr. Muir.
Correct.
Let's look at paragraph 97 and 98. In there, Ms. Reed states, among other things, I know Brian Higgins had a role in helping kill him, helped him get in the snow, and helped frame him. And then Mr. Vieira asks Ms. Reed, you make such strong statements about, I think, Colin Albert killed him. I don't know how without getting sued, because I don't even know if you're gonna. I hope you're gonna use that. And Ms. Reed responds, if Colin can prove I'm lying, and this is defamatory, he can sue me. So my question is, how can statements by Ms. Reed outside of a criminal trial, 3 days before the case went to the jury, to your own words, documentary filmmakers that apparently were not going to be released to the public at that time, being considered petitioning activity? It's almost the claims and statements to the filmmaker petitioning activity appears to presume that Ms. Reed was either seeking to influence the jury or she knew there was going to be a hung jury. How could it possibly be petitioning activity?
Well, firstly, the criminal trial is still ongoing. The jury hasn't got the case yet. The jury hasn't decided. So the judicial proceeding is still ongoing. And if we actually look at what happened, there was a mistrial, which leads to
Mr. Miura to release those statements.
I'm sorry.
The intent was for Mr. Miura to release those statements prior to the jury.
Well, I don't know what the intent was with respect to when this documentary was going to be released.
Sure as hell wasn't going to be released in 3 days, was it?
Well, even if it's going to be released in the future, she ultimately is still in the process of being prosecuted. The trial hasn't ended. It's still under adjudication. It's still a proceeding. These are still statements. These are still protected petitioning speech, regardless of what Mr. Muir's intention was or when he was going to release this documentary. But ultimately, there's a mistrial, and she's tried again and has the same defense, and that leads to an actual acquittal. So this is also to enlist participation. This is also in connection with the judicial proceeding that's ongoing, and therefore falls squarely into the statute's definition.
If it's made 3 days during a pending criminal trial, made 3 days before the case is going to go to the jury, and how is it made to enlist public participation?
In the future, because there's, or at the time, it's still part of a judicial. If you take aside the public participation enlistment aspect of the statute, it's still in connection with the judicial proceeding. Whether or not the documentary was published that night, that morning, or 3 weeks from then, it's still in connection with the judicial proceeding. It's still petitioning activity. The statute doesn't say when the judicial proceeding has to have concluded by. It says in connection with a judicial proceeding. Taken to its logical conclusion, it might be that she's even been, hypothetically speaking, convicted, and she can still say those things and argue it's in the anti-SLAPP statute protection because it's in connection with the judicial proceeding.
So plaintiff owner responding.
Yes, Your Honor, I do. What Ms. Reed's counsel has just suggested is that there is no limit. There need be no nexus between what she says and the likelihood or the plausibility that it will reach a governmental body. He just said that even post-conviction, and we actually have allegations that she made defamatory statements, both she and Mr. Kearney, post-verdict. But what they're saying is even post-verdict, because she in the past had been subject to a criminal prosecution, she is free to defame people, no matter the audience. Just because she's commenting on somebody else's guilt, not her own, somebody else's guilt. Blakesley says exactly the opposite. Blakesley says that this court is required to assess if a plausible nexus exists, and in doing that, analyze the objective indicia of a party's intent to influence a government proceeding, such as the timing, audience, and content of the statement. That's exactly what you were just trying to do here. With respect to the murder allegations, the audience of Ms. Reed's statement to Ms. Murr is not the broader public. She's saying that in a closed private room to Ms. Murr and the small production staff around her. Now, if that statement is later published, she may be on the hook for additional damages, but the defamation that she articulates to Ms. Murr is not enlisting public participation in anything. It is a private statement to Ms. Murr and her small production staff. And as you point out, I think, or I pointed out, the idea that there was a plausible nexus between that statement and something that was under review by a judicial body is so far-fetched as to be totally unreasonable. That statement wasn't going to reach any judicial body. By the way, Karen Reed, if she wanted to reach a judicial body, had every opportunity to do that. Instead, she's talking to a documentarian in private and accusing all of my plaintiffs of murder. Period. There is no nexus to any judicial proceeding. And this does get to the post-verdict statements that we allege she made and that Mr. Kearney has made up until last month. I can touch on that now because the issue of having to analyze whether there's a plausible nexus is one that's going to apply equally to those statements. And what Ms. Reed has argued is that her statements in, I believe, 2026 to the Rotten Mango podcast, in which she again defames our client post-verdict. Well, she says, she argues, that has a plausible nexus to the O'Keefe family's civil case against me, and that by accusing these innocent people of murder, perhaps I can convince the O'Keefe family to drop their case against me. Now, the O'Keefe family isn't a governmental body. They're a private litigant. That's not petitioning activity. And Mr. Kearney equally has a lame excuse for his post-verdict statements, where he says, well, there's the statute of limitations for murder still exists. I can spout accusations of murder into the void, and there's some plausible nexus that some governmental entity will pick that up and then prosecute these innocent people for murder. That is simply not plausible. It's not reasonable. It's an after-the-fact justification that has no support in any of the case law. Go ahead.
Ray Sullivan, you want to respond?
Your Honor, the statements are still in connection with a judicial proceeding.
Okay. Attorney Conley, yes, the characterization, lame excuse might warrant some response.
Thank you, Your Honor. And I'll note that the argument that was just made that post-verdict statements can't be petitioning was not connected to any element of the definition of petitioning in the anti-SLAPP statute. So I'll read one. Any statement reasonably likely to encourage consideration or review of an issue by an executive body. The Norfolk DA's office still exists. Karen Reed has been found not guilty. If Karen Reed's not guilty, somebody else is guilty. Aidan Kearney fervently believes that the plaintiffs are guilty. It is still possible for them to be charged. In fact, one of the allegedly defamatory statements that they identify in this case is a TV interview that he did, not one of his YouTube videos, but a stand-up TV interview right after the verdict. And Aidan Kearney said, "I would hope now that Karen Reed has been found not guilty, we can all unite and demand that the Alberts and the McCabes be charged with the killing of John O'Keefe, because they're the ones who did it." That is a demand on the government to bring charges. It is a statement also that is reasonably likely to bring about further public participation to demand that charges now be brought against the real killers. That is petition.
Attorney Sullivan, we didn't give you the chance to argue your motions. What would you like to add?
Your Honor, what I'd like to add is, without regurgitating what we've already said about state of the Bristol Ascot frame, the sole crux of the complaint, the amended complaint, this lawsuit against my client, is solely based on statements that are petitioning activity, protected and immunizing her under the anti-SLAPP statute. The second prong of the step of the framework requires the burden to shift back to the plaintiffs to show that the statements are devoid of any factual support or any legal basis. We have put forward enough evidence. You referenced the affidavit and the transcripts attached to my declaration affidavit. That's in there, and they started to in our brief. But the facts that establish that stage 2 of the framework, most importantly, my client was acquitted of the prosecution's charge that she is responsible for John O'Keefe. The case of Faber versus Walton, the holding was judgment in favor of a party to litigation is conclusive evidence that petitioning activity was not devoid of any reasonable factual support or arguable basis in law. She submitted an affidavit that she did not strike Mr. O'Keefe with her vehicle.
What's the nexus between the finding of the Norfolk Superior Court in a criminal case against one defendant to claims against?
Because her petitioning speech has to be supported by facts. They have to disprove that there are facts to support her petitioning speech. So that fact is highly relevant. She didn't strike Mr. O'Keefe with her vehicle. The chief medical examiner, Dr. Irini Scoibello, testified that Mr. O'Keefe's injuries were not consistent with a vehicle strike, but they were consistent with a physical altercation. Mr. O'Keefe did not show signs of a physical altercation before Ms. Reed dropped him off at 34 Fairview Road in Canton. They did not have an altercation at the Albert's house. He suffered a wound on the back of his head, which was consistent with falling on a ridge surface present in the basement garage at 34 Fairview Road. Mr. O'Keefe had wounds on his arm consistent with a dog bite. There was a German Shepherd in the home with a history of aggression. That's also testimony from the trial. Mr. O'Keefe's phone was at some point inside the Albert's home. That's testimony from Mr. Ian Whiffen. Ms. McCabe used her phone at 2:27 a.m. on January 29th to type in how long it takes for a person to die in the cold. That's the testimony of Richard Green from the trial. In the early morning hours, of January 29, 2022, Mr. O'Keefe's body was not present where it was later found. That's the testimony of the plow driver, Lucky Lothrick. And then there's the testimony from Dr. Laposada, the former chief medical examiner for Rhode Island, and a professor at Brown University, who opined that Mr. O'Keefe died from a massive skull fracture that was inconsistent with a vehicle strike. Those are the facts that the plaintiffs now have to prove are somehow devoid. We're devoid of proof. So the statements are petitioning. They are covered by the anti-SLAPP statute. The amended complaint rests solely on those statements. And the support for her petitioning activity is factually supported by what I've just read and what I've submitted to the court attached to my affidavit. For those reasons, Your Honor, for those reasons, I ask that the court dismiss the lawsuit against my client and award her attorney's fees as is provided under the anti-SLAPP statute.
Thank you very much. Matt, you want to respond to Ms. Reed's arguments?
Just briefly, Your Honor. And before I do, I did just want to point out in response to the court's question earlier to Attorney Pyle about whether posting to social media is by its very nature petitioning activity. We cite the Sheehan case in our brief, which stands for exactly the opposite. I hesitate, Your Honor, to even engage with what I just heard, because I think it's prejudicial to my clients to even entertain what I believe is just nonsensical recitation of evidence that doesn't implicate any of them in crimes that has been shown to be discredited. And I'll start by pointing out that he doesn't mention Colin Albert once. Doesn't mention him once. And the reason he doesn't mention him once is because he knows that the undisputed evidence, as we present in our brief, is that Colin Albert wasn't even there when Mr. O'Keefe arrived. And because he knows that the other evidence that they suggested implicated Colin Albert in some sort of altercation, that is that at some point he had scab knuckles, that they were in possession of photographs that show him before that and after Mr. O'Keefe's death with completely uninjured knuckles. So I only raise that to show just how frivolous these arguments are. With respect to Ms. McCabe, Attorney Seligson just said again here in open court that Ms. McCabe Googled how long to die until the 2:27 a.m. That is not true. That was established to be definitively not true in the second trial. Ms. Reed did not allege it in the second trial. She didn't even call the discredited expert who Mr. Seligson just cited. To the contrary, Celebrite officials who managed that software testified without contest that that search showed up at 2:27 a.m. because a previously opened window was used to conduct the search at after 6 in the morning. And that was a feature of the software and no evidence at all that this search had happened in that time. And obviously it's absurd to even suggest it because then there are two searches, I believe it's 623 and 624, that are miskeyed in exactly the same way as the prior search. It's just nonsense. And I think that the important thing is, as you point out, the fact that a jury was not able to reach a verdict as to the fact that a jury concluded that there was not sufficient evidence beyond a reasonable doubt to convict Ms. Reed of these crimes is not affirmative evidence that anybody else committed them, much less witnesses who have never been targets, never been subjects, testified in open court multiple times. It's just offensive to hear that type of argument here. Now, I don't think you're ever going to get into that stage of the analysis because I think, as we've shown, none of the allegations we've made against Ms. Reed or Mr. Kearney implicate petitioning activity. I think we've shown it. I'm sorry? None of the actionable. I mean, I think there is, as Mr. Pyle has suggested, Mr. Kearney separately, now I'm not acknowledging that this was petitioning or not, but Mr. Kearney has engaged in criticism of the Norfolk DA's office, the Canton Police Department, and the state police. None of that is at issue in this case. And yes, Your Honor, none of his accusations of our clients that they committed murder was petitioning activity. Not a single one. Not a single one. And there is no case to suggest that that sort of accusation against a private citizen, untethered to any effort to report to the government, is petitioning. None. And so the question I think that this case presents is whether or not this court is going to radically expand anti-SLAPP protections to include what historically has been considered defamation per se, and shut the courthouse doors to people like my clients who've come here seeking and invoking the court's protection to press their claims, or whether they will have no civil recourse, not just them, but any resident of Massachusetts who is falsely accused of a crime by another citizen untethered to any petitioning activity, whether they will have civil remedies or not. And to me, the case law that we cite in our brief makes it clear that the narrow purpose for which the anti-SLAPP statute was enacted certainly does not extend to what historically has always been understood to be defamation per se, the worst type of defamation, the accusation of one citizen of another, a false accusation that they've committed a heinous crime of murder, when that has not been tethered to any report, any petition, anything with respect to the government. Thank you.
Yourselves, anything else?
No, Your Honor, I stand by my.
Very hot.
Yes, Your Honor. The suggestion is repeatedly made that accusations of murder against private people are not protected by the anti-SLAPP law. That is not the law. And Mr. Maddy just said that those statements can't be protected by the, quote, very narrow purposes for which the anti-SLAPP statute was enacted. The Supreme Judicial Court in the Duracraft case noted that the language of the anti-SLAPP statute is, in fact, very broad. It broadly protects petitioning activity, yes, even when it results in the dismissal of an otherwise meritorious defamation claim. It has long been the law, at least since McDonald versus Payton, which we've cited in our brief, that anti-SLAPP applies to defamation claims. It doesn't matter if it's defamation per se, which is one of the old common law characterizations of defamation, the commission of a crime, loathsome disease, or whether it's defamation per quod. It applies to defamation cases. These plaintiffs' defamation claim is based solely on Mr. Kearney's accusations that they committed murder, and those accusations were inextricably bound up in his protests against the prosecution of Karen Reed and the failure of the government to investigate the plaintiffs. The notion that there's no reasonable factual support for Mr. Kearney's petitioning activity is laughable, given the extensive evidence that you've heard about at the trial and that our brief explains in great detail. Mr. Maddy didn't say anything about the Ford Edge that Lucky Lawford saw parked in front of 34 Fairgate. There's no explanation for that. The notion that he cannot make these statements, comment on a pending criminal case in order to get people involved in this matter is simply not accurate. The anti-SLAPP statute provides very broad protection for petitioning activity. And it doesn't require that anybody report anything to the government. It extends to statements that are made that are intended indirectly or directly to reach the government. That concludes my argument on the anti-SLAPP motion. I did want to raise one other housekeeping matter with Your Honor in order so that the record can be clear. Back at the Rule 16 conference, Your Honor asked the plaintiffs to file a thumb drive containing all of the allegedly defamatory videos. We got it. You have received such a thumb drive? Oh, I didn't know that because I didn't receive a copy. I'm glad that that thumb drive is now in the record. I know there was a thumb drive attached to the anti-SLAPP motion that may have contained a few of the videos. I'm not sure if they got one.
Docket, right?
I don't think we noted that we received it, no.
Oh, okay. All right. They sent it in. They sent a thumb drive in with the links and all that.
Containing every allegedly defamatory video in the case? Okay. Thank you, Your Honor. That satisfies me on the issue. I would request a copy.
Happy to give you a copy. Your Honor, very briefly in response. The Duracraft case cited by counsel.
It was cited by everyone.
Which
I cited it too, so.
Which I relied on in saying that the purposes of the anti-SLAPP statute are narrow, reads as follows. Section 59H is, quote, strong medicine and used only in a limited context, requiring, quote, necessarily narrow and strict construction. That's what I was relying on when I made that observation to the court. And the last thing I'll say is, it is of course true that the anti-SLAPP statute applies to defamation. The point that we've made, and I think the point that counsel doesn't even dispute, is that where the defamation involves accusation of a private citizen of murder, and that accusation is not made to a law enforcement agency or the government, that it has never been given petitioning protection.
Thank you all for your arguments. The matter will be taken under advisement. Can I speak with all counsel at the side of the bench, please?
All rise.